Thank you. You are now being joined to your conference.
Your line has been muted.
For Olswang's webinar on payment in construction contracts. I'm Francis Ho and I'm the Head of Construction at law firm Olswang. Just to introduce the webinar, if there's anything you'd like to discuss regarding the broadcast, feel free to contact one of us. Our contact details are displayed at the end. To introduce our speaker for the session today, Ben Worthington is a Senior Associate in our construction team. He specialises in disputes and has acted extensively for contractors, developers and professional teams in a wide range of construction matters. He has particular expertise in complex litigation in Technology and Construction Court of England and Wales, and he's also represented clients in adjudications, arbitrations and mediations. We're going to have a number of questions that clients have asked us about interspersed throughout the session today. I think a good place to start, Ben, is if you explain the payment provisions that must be included in building contracts.
Yeah, thank you, Francis. Well, the Construction Act has a series of mandatory requirements with which all construction contracts must comply. And if the parties' payment terms do not comply, then the implied terms kick in. And those terms are contained in something called the Scheme for Construction Contracts. And to my mind, there are 3 or 4 sort of key mandatory requirements with which all construction contracts must comply. The first is a right to interim or periodic payments where the contract period is 45 days or more. Now, the Act says nothing at all about the timing and amount of those payments. That's left entirely to the parties. We're used, I suppose, to seeing probably monthly payment terms, but that's not a specific requirement of the Construction Act. And it may well be the case that some contracts that we see have longer payment periods, 2 monthly, 3 monthly, or whatever, and sometimes milestone dates, so that payment is linked back to progress of the works. There must also be an adequate mechanism for calculating the sum due, the due date, and the final date for payment. And again, the Construction Act doesn't say very much about what these individual aspects mean and what an adequate mechanism looks like. But if we look at something like the JCT contract, we'll see that the sum due is usually calculated very sensibly by reference to a sort of gross valuation of works and materials to date, less of course previous payments and retentions. The due date is usually a specified date in the contract, perhaps the 20th of every month or whatever, and the final date for payment will be a specific number of days after the due date. And the final date for payment is the key date by which, if no payment that falls due under the contract is made, then there are potentially quite serious and draconian consequences for the paying party. For example, the contractor may have the right to suspend performance and ultimately to terminate the contract. All of this is underpinned by a payment notice regime, and just to sort of quickly summarise that, I think the 2 really key things to remember about the payment notice regime is, well, firstly, no notice, no payment. So for the contractor, it's got to have a valid payment notice in place, or it's not going to be paid anything at all. And that the sum payable is the sum stated in the latest properly issued payment or pay less notice. And it follows from that the employer actually has an awful lot of control over the payment process, because it will normally be the employer that has the final say in terms of issuing the final notice. And that gives the employer a lot of power in this process, because provided the employer issues its notice in time and in the correct format, the only way that the contractor can then challenge the employer's valuation of the works is to start an adjudication to challenge it.
Of course, in the UK, the most popular building contracts are those published by the Joint Contracts Tribunal. How do the JCT's suites of contracts implement this?
Well, under the JCT standard building contract, the due dates for interim payments are set out in the contract particulars, and it's normally a specific date, as I said before, the 20th of the month or whatever. And then in the week before the due date, the contractor is entitled to make its interim application, and that will state the sum that the contractor considers will become due at the relevant due date. So it's important to note there that the contractor is entitled to include within its payment application work that it expects will be carried out but is not yet being carried out between the application date and the relevant due date. The contract administrator then issues its interim certificate not later than 5 days after the due date, and that will state the sum that the contract administrator considers to be due at the relevant due date. So that effectively is a payment notice for the purposes of the Act. If the contract administrator fails to issue its interim certificate, then the contractor's interim application becomes effectively the default payment notice. So it's the sum that the contractor applied for which becomes due and payable, provided always that the contractor issued a valid payment application. I think that shows just how important it is for the contractor to make sure that it issues its payment application strictly in accordance with the terms of the building contract, because if it doesn't do so, then it may end up in a position where there's effectively no effective payment notice in place. And finally, the employer is entitled to issue a pay less notice not later than 5 days before the final date for payment. And there may be various reasons that the employer wants to do that. It might, for example, want to deduct liquidated damages. It may be the case that a defect or something like that has arisen since the original payment application, so it wasn't taken into account in either the payment application or the interim certificate, but it has arisen, and the employer wants to make sure that some money is set aside to account for that, or simply that the employer wants to put forward its own valuation of the works. If it doesn't agree with the contractor's valuation or the contract administrator's valuation, then it can, in principle, use a pay less notice to put forward its own valuation of the works, again highlighting just how much control potentially that the employer has over this process.
So what happens if the paying party fails to issue a payment notice or a pay less notice in time?
Well, there are certainly serious consequences for both for any party that fails to issue a notice when it should do. I've already touched upon the consequences for the contractor, which is effectively, if it doesn't get the payment notice in, payment application in on time or in the right way, then potentially it's going to be in a situation where it has no right to payment at all, at least in that relevant application period. For the employer who fails to issue a valid payment or pay less notice, it's effectively agreeing the value of the works for the purposes of the current interim application. And so the employer must then pay the sum stated in the contractor's application, irrespective of the true value of the work. And we see that very clearly in the ISG and CVIC case, which probably most of our viewers will be familiar with. What we've seen in the courts is a series of cases in which contractors have adopted what we might call a smash and grab technique, whereby they issue possibly somewhat overinflated payment applications. The employer, or more likely its professional team, for whatever reason, fails to issue a valid payment or pay less notice, and the contractor then starts an adjudication where it asks the adjudicator to determine the amount due. The adjudicator will look at the facts surrounding all of this and see that there's no payment application or pay less notice in place, and award the amount that's been applied for, irrespective of the true value of the works. And in those cases where the employer has then sought to start a second adjudication to try and determine the true value of the works, the courts in ISG and CVIC and in other decisions have made it clear that that second decision will not be enforceable So effectively, the employer is stuck with the overpayment, at least in the current payment period. I suppose that raises the question, what can the employer do? And none of the options are necessarily particularly attractive. The best option, of course, is to correct the overpayment in the next valuation. And I think the important thing to keep in mind here is that the employer is not entitled to recover any overpayment at an interim stage unless there's an express contractual right to do so. So the JCT and other standard form contracts don't recognise negative valuations. The employer can't simply claw back overpayments in the next period. And what it can do, usually, is set off the overpayment against sums falling due at subsequent payment dates. And it can keep doing that every month until the overpayment is properly corrected. And that works fine, provided, of course, in the meantime, the contractor doesn't go bust, and provided that there's sufficient value left in the works. And what we see in cases like ISG and CVIC is often this problem arises where the contractor makes a very late application, by which I mean an application that's made right at the end of the works, possibly after practical completion. I think in ISG and CVIC, it was effectively an indicative final account application for a very substantial sum of money. And of course, in those circumstances, there's simply not sufficient work remaining to make any adequate set-off to protect the employer. And in those circumstances, all it can really do is wait for the final account stage, and that can be a very long wait indeed. And in the meantime, of course, it's carrying that insolvency risk.
That's very helpful. Now, we've been asked what a paying party can do if the supplier deliberately overstates its account. Is this something that a paying party can protect itself against?
Yes, I think the obvious answer to that is that the employer can serve the relevant notices, and I think that a court is unlikely to have very much sympathy for an employer that is faced with an overinflated payment application but hasn't served the correct notices. The notice regime is how it protects itself. And rightly or wrongly, I think it is sort of generally recognised in the industry that payment applications often are overstated. There was quite an interesting comment by Mr. Justice Coulson in Harding and Pace, a decision a couple of years ago, in which the judge specifically said that everyone in the construction industry knows that contractors' claims are often overstated. That's unfortunate, but that's the position that we are in. And as has been made clear in ISG and CVIC and lots of other cases, the best thing that the employer can do to protect itself against that situation is simply to serve the relevant notice. I suppose it is true that fraud unravels everything, and so if you were in a position to be able to establish that a contractor has issued a fraudulent payment application, then it may well be that you could raise a challenge on that basis. But I would suggest that that's a much more difficult way of going about things, much easier to serve the notice than to try and argue that a fraud has taken place with the very high bar associated with establishing that.
If so much turns upon the employer serving a notice against the contractor's application, what prevents the contractor from issuing a fresh application every few days?
Well, payment applications must be issued strictly in accordance with the building contract, and the courts have shown in many cases over the last sort of year and a half or two years that they are willing to scrutinise contractors' payment applications. I think what's going on here is that the courts recognise that there are very draconian consequences for the employer if it fails to serve a relevant notice, and so they are prepared to look very closely at the contractor's payment applications to ensure that those applications are valid applications being made in accordance with the building contract. Last year we had the Leeds and Waco decision where a payment application was made 6 days earlier than was provided for in the building contract, and the court found that that payment application was invalid. Quite interestingly, in that decision, the employer had regularly processed and paid payment applications that were made 3 or 4 days late. So the court said that because the employer had done that, it had regularly processed late payments, it wouldn't have been entitled to complain about a late payment application. But because it had only processed and paid one other early payment application, it was entitled to complain about that. And another decision from last year, Caledonian and Mar, again, quite similar facts there. The contractor issued its application halfway through the payment cycle. And I think in all other circumstances, all of the payment applications that it made have been right at the end of the month. And again, the court said that it couldn't make an application early. And also raised some concerns that the application itself wasn't clearly a payment application related to the relevant payment cycle. And in those circumstances, it hadn't been made in time, and it also wasn't clear that it was intended to be an application for payment, and therefore it wasn't a valid payment application. In Henia, the contractor claimed that its application that was made at the end of April was a valid application for May. So in those circumstances, the contractor accepted that its April application had been made too late for the April payment cycle, but then argued when it didn't receive a valid payment notice or pay less notice in May, that effectively its April application had become a default payment notice for the May application date, and the court said that no, the application wasn't valid because it was clearly intended to relate to April and not to May, and was therefore not free from ambiguity. And I think one of the important things that sort of comes out of some of these cases is not just a question of the timing of the application, but the form of the contractor's payment application is also very important. So we see, for example, in the Interiors Group case earlier this year, the contractor had made its payment application, but had written on it that it was its initial assessment, and the court said that that was not a valid payment application because, again, it wasn't unambiguously clear that it was intended to be a payment application at all. Probably quite hard on the contractor in that case, but underlies the really strict requirements that the courts have in terms of making it absolutely crystal clear that what the contractor intends to rely upon is a payment application. So I think just to sort of bring that back to your initial question, yes, the court won't entertain a situation where the contractor is making an application every few days in the hope that the employer sort of trips up and fails to issue a valid payment or pay less notice. The payment applications do have to be made strictly in accordance with the contract.
That all seems very comprehensive. Do you have any other practical advice or tips relating to the payment process?
Yes, I think you know the best protection for an employer would probably be a clause that allows the employer to recover any overpayment on an interim payment, so that, you know, in other words, that becomes repayable in the next valuation. Of course, in reality, commercially, trying to negotiate that kind of clause will always be difficult, and we don't see them very often, certainly on substantial building projects. A very basic tip, but one that I think is useful, is simply to diarise all of the payment due dates and relevant payment notice interim certificate dates right at the outset, because, you know, what becomes clear looking at some of the decisions in the court is that often it's simply the case that a key date has been missed, And we really, in most situations, do know what the relevant certificate dates are right at the outset of the project. So there's no reason not to put those into diaries, get them up on the wall, make sure that they're diarised, scheduled in whatever way you can to make sure that nothing slips through the net. I think related to that is make sure that key contractual dates are absolutely clear. We had a decision earlier this year, part of which was about the meaning of a term in a building contract, which said that a notice was to be served at the end of each calendar month. And what does that mean? Does that mean that it has to be served on the last day of the month or within a few days either way? It's not clear, and it's much better, I think, to use specific days rather than imprecise language, such as appeared in the Nottingham City Council case. I think if you're dealing with a large portfolio of projects, it does make sense to synchronise the payment due dates and make it the same date each month and synchronise that across all of the projects that you are dealing with. Again, just helps minimise the chances of anything falling between the cracks, although clearly it might mean that you're very busy on particular days of the month. Make sure that you leave yourself enough time to deal with the contractor's payment application. There's some flexibility there, so that you can create a buffer between the issue of the payment application and the payment due date, and make sure that you give yourself a week or whatever you think you need to consider properly the contractor's payment application. And don't allow the contractor to submit applications outside of the contract procedure. And this is the point that falls out of the Leeds case, that if you do consistently let the contractor make late or early payment applications, then effectively you or the contract administrator may effectively be varying the building contract. And whilst there may well be situations where you want to help the contractor, and if it makes an early or late payment application, you're perfectly happy to pay it, then I would recommend that you do so, but do so making it clear that you're not giving up any right to insist upon a proper payment being made on time in the future. I think always be careful with payment schedules. Do double check dates that appear in payment schedules, because they can be wrong, and that comes across really clearly in quite a recent case, the Bouygues and February decision. There, the employer's payment notices were normally issued on the 20th of each month in accordance with a schedule which was attached to the building contract. However, the November date, as specified in the schedule, was the 23rd of November, and the employer issued its notice on that date, issued it on the 23rd, in accordance with the schedule. The contractor later complained that the employer was not entitled to issue its notice later than the 20th, and the court agreed with that and said that the schedule contained an obvious error, and therefore the employer's notice was out of time. Again, I think quite tough on the contractor. After all it had done was to follow the schedule that the parties agreed, but I think does highlight the importance, certainly if you're putting together these sorts of schedules, to double and triple check it to make sure that there's no problem with it. And finally, and at risk of repeating myself, I think just make sure that notices are issued on time and are absolutely crystal clear as to what they relate to. And I think that although a lot of the cases that we've been talking about relate to contractors' payment applications, I think it's fair to say that the employer is under a similar obligation to make sure that any payment or pay less notice that the employer issues is also clear, unambiguous, and issued on time. So those are my top tips. I think that the JCT are in the process of releasing their 2016 suite of contracts, and I was wondering what we can expect, Francis, in terms of any possible changes to payment terms in the JCT suite.
Thanks for that, Ben. I appreciate that's the end of your talk, and I'm sure viewers would have found it very informative. Turning to your question now, because the JCT contracts are intended for the British market, the 2011 contracts, of course, already take into account current legislation regarding payment. That, of course, hasn't really changed since that edition of the contract. However, the JCT new editions often react to case law, generally to clarify the existing contract position or perhaps in light of particular court judgments to preserve it. The current update is being rolled out in contract families. So the new minor works building contract family was published earlier this summer, and next on the slate is the updated design and build contract, which is due any day now. One of the major changes from 2011 has been to simplify the payment procedures and to make them consistent, whether in main contracts or subcontracts. So the concept of interim valuation dates has been introduced. There's now also no difference between the periods of interim payments, whether this is before or after practical completion. The JCT has said it will embrace the UK government's Fair Payment Charter. The idea of this is to reduce the periods of payment, and we've seen a number of employers and contractors sign up to it. The JCT contracts have actually been generally pretty good about this. So we'll wait to see whether the Charter's other principles, such as the greater use of project bank accounts by central government clients or the removal of cash retentions, are encouraged. Now that brings us to the end of today's session. Thank you very much for joining us. On the screen, you'll see our contact details again, so feel free to get in touch if you have any follow-up questions. Thank you again, and on behalf of Ben and myself, goodbye.